Thanks for joining us. I'd like to welcome everyone to today's webinar. Will NYCRR Part 500 become the National Data Protection Standard for financial institutions? I'd like to introduce our presenter. Joining us today is Scott Giordano, VP of Data Protection at Spirion. Scott's a highly regarded privacy attorney with over 20 years of experience. So welcome, Scott. Please take it away.
Wonderful, Abby. Thanks for having me on again. All right, let's go to our agenda, and I want to welcome everyone to the webcast. What we're going to do today is I'm not going to do a control-by-control description of NYC Part 500. Presumably, you've all done that over the last 2 years. I'm really going to talk about it from a policy perspective, but I'm also going to talk about some controls, specifically third parties, and some things that I think are noteworthy. So we'll talk about why Part 500 and why this presentation in general. I'll do a timeline, which I know many of you are already facing the March 1st deadline. We'll talk about data privacy, which is something that does not get enough attention in my view, and how this compares to GLBA. Also, we'll go through some key trends, and if you asked questions in advance when you signed up, I've got those ready to go to answer, but certainly if you have questions during this, feel free to ask. If I can't answer it or it requires more research, then I will be happy to go do so and just email you back. So that's what we're going to do. So we'll go to the next slide. So first up, why this presentation? Why is this even necessary? If you've been on any of my webcasts previously, you know that we in the US take a sectoral approach, okay? Meaning that we go industry by industry, and some industries have higher standards than others, healthcare being high on the list, financial services being high on the list, defense contractors and so forth, some less high, so retail, for example, and some that really don't get a lot of regulation in general, like tech firms, for example, although there are some exceptions to that. So really we use a sectoral approach, and it's just not working. Traditionally, it works because before the internet times, it was relatively easy to control how information security was effectuated and to control personal information. That's all gone. And sectoral approach really is melting down, unfortunately, here in the US and elsewhere, and I think this is why the GDPR and other non-sectoral approaches really have taken off so well. Part 500 has been called first in the nation, first of its kind. It really is. The requirements are extensive, the scope's extensive. If you're on this webcast, you probably all know this since you're in the industry. Also, the Treasury's endorsement of what's called the Model Insurance Security Law, which is essentially a copy, for all intents and purposes, of Part 500. The fact that the U.S. Treasury's endorsed it, that says a lot. And so this is sectoral still. But I think that by the end of this presentation, you'll agree that we are moving away from pure sector, and this is becoming more horizontal, if you will. I'll show that to you as we go through this. So let's go to the next slide. So I'm going to summarize Part 500, and I want to emphasize things that, again, I think things might have been missed by commentators. So who's covered under this? It's any organization, any person for that matter, that has to get a license or the equivalent. You can call it a registration charter, a piece of paper, whatever you want, from the authorities under the banking law, insurance law, or financial services law. That's a long list. And then recently, on June 25th, credit reporting agencies were added to this list. That is perhaps the most important aspect of this that I don't think has gotten enough attention. The fact that CRAs are now included on this, because the bar is already high for financial institutions, and this now adds to the bar for these organizations like Equifax and so forth. Very big deal. I don't think it's gotten nearly enough press. Let's go to the next slide. Here's a couple of examples of just organizations that are subject to this. So banks, not surprisingly, whether it's a state charter bank, it's a private bank, any kind of licensed lender, a trust company, mortgage brokers, non-for-profit mortgage brokers, I mean, the list goes on. HMOs and what's called CCRCs, continuing care retirement communities, and service providers, which is perhaps probably one of the biggest changes here is just the level of restrictions on third parties and how much scrutiny they're receiving. So the net of it is that, yes, it's focused on financial services, but it's a pretty broad brush, a pretty broad group of organizations that have to comply. Let's go to the next slide. And so let's talk about the what. And again, I'm not going to go control by control, but I do want to highlight some things that I think are really crucial. One is that you're required to have a cybersecurity program, not just a policy, but an actual program, meaning that there are pieces that fall into place. You have the actual paper policies, you have technology, you have leadership, you have all the team members and all the people that all work together as a united whole. That's huge. Even more so is the idea that you must appoint a CISO, and that CISO must report to the board periodically about the state of information privacy and security within the organization. Folks, that is perhaps, if you want to look nowhere else in this statute or this regulation, that's perhaps the biggest thing, because essentially what DFS is saying is that you can't hide, you can't pretend that you didn't know what was required, you can't say that you didn't understand if something bad happens. There's no way to hide. This is essentially putting the onus on one person. And it's, if nothing else this law has done, it's really provided a model for the rest of the nation to say, hey, you must appoint someone who's ultimately responsible for this. And if it's important to the board, it's important to everyone else. So I think that's perhaps the biggest aspect of this regulation that I really think does not get enough press. Also, two items on here about the program that I want to bring to your attention. One is this idea of defensive infrastructure. I've never seen this before in information security or privacy. So it's a new idea. It's this idea that, I'm just summarizing what I think is what they were getting at DFS. This idea that you simply are not putting together controls in a place and saying, okay, I've checked all the boxes. This is well thought out. You're using some kind of a system. It could be that you're using zero trust, for example, or using defense in depth, or using some other kind of system. It's not just a pile of controls and checkboxes. That's a big difference. Also, item 5, this idea of recovering from cybersecurity events. So it's not just the CIA of the CIA triad. You're all familiar with that. What's interesting is that the GDPR has another element to the CIA triad, and it's resilience. So it's not just confidentiality, integrity, availability, it's also resilience. Again, that's new. I think that NYDFS probably borrowed from GDPR when they talked about this idea of recovering from cybersecurity events, because it's the idea that you just are not only defending, but you're able to bounce back after you've taken a hit from a threat actor. So very interesting. Again, this is something that you really don't see typically here in the US. And potentially, I think this is the shape of things to come. Let's go to the next slide and let's talk about the compliance period. So compliance period, as you all likely know, is going to wrap up on March 1st, and you'll be certifying very shortly about third parties. And I'll talk about third parties in a bit. In fact, I have a timeline I'll share with all of you. So if we go to the next slide, you can see how DFS did this. They passed this law about 2 years ago, and it came into force March 1st, 2017, and they phased it so that you've got every 6 months, you've got another set of controls or requirements in place. So in the first deadline, you had the program and the policy, and a CISO. So very good to have someone run the program and have the program to begin with. And then other things like access privileges and so forth. And then over every 6 months, you add more layers and more layers. And so March 1st, as all of you know, is now the deadline for certification of dealing with third-party service providers, or TPSPs. So let's talk about those. Before we do, though, I'm going to put up a poll question here. It's only a poll question, so I promise you I won't bombard you with these. But I just want to know, do you think that your third-party service providers are going to be able to meet their obligations to your organization under Part 500 after the deadline? So if you would select one of these, let us know what you think. I'm very curious to see what the outlook is for third parties, and I'll tell you why in just a moment. So I'll give you about 30 seconds or so to do the poll, and then let's see what we get. Also, if any of you have questions at this point, now would be a great time to start sending them in. So, wow, likely no, we're leading the way here. That's amazing. That really is. I would not have thought that. What's interesting about this is that there's a lot of attention that was paid to third-party service providers, and I'll talk about that in just a minute. So very interesting. Thank you, Abby, for doing that poll. Let's talk about the Part 500's second anniversary that's coming up, and that'll be the next slide after this. DeLillo of the NYDSF put this out, I guess about 4 weeks ago. She put out this memo, and essentially what it was is the second anniversary memo. Two pieces of it I thought were very interesting. I do recommend you all read this. One was that pursuant to the regulation, the department got about 1,000 notices of events. So as all of you know, you're required to report cybersecurity events within 72 hours to the department. And so it looks like that's taken place. So I thought that was interesting, that breach notification or event notification is taking place. Secondly, and I think this is really important, she states that while all aspects of DSS are important, recent attacks on email and transmissions highlight the importance of full compliance with MFA, encryption, and training. If you've been on any of my webcasts in the past, you know that I'm a big fan of training, but here you see MFA and encryption have really come in as important controls. So a big deal. So do read this if you get an opportunity. I think it's a nice summary of the successes. So let's talk about why Part 500 to begin with. Why do we even need it? This regulation came about as a result of a 3-year effort to identify and mitigate cybersecurity risks in the financial services sector. And there was a report that was published that essentially summarized all of this. And I highly recommend that you all take a look at it after the webcast. I put a link here. And you may say, well, this is great, Scott, but we already have GLBA. We've got the FFIEC audit requirements. Why do we need this? Why bother? What's changed? Well, keep in mind that GLBA was passed in 1999. A lot's changed since then. And if we go to the next slide, I'll highlight some things that I think are really important and bear to this becoming a nationwide standard. So talked about appointment of a CISO and briefing to the board of directors. That's huge because essentially you're citing someone as the person that's going to take the fall if things go wrong. So right away you're putting responsibility where it needs to be, and now it's a board of director issue, so it's important to everyone. You have your annual certification of compliance. That's atypical. The only time I've ever seen that elsewhere in a large scale is in the defense sector, where defense contractors have to certify compliance with DFAR 7012. So that's a big deal. Specific controls to protect non-public information when working with third-party service providers. That's a big deal because previously you were just asked to say that you have investigated third parties and they've told you what they're going to do in terms of information security. Now, specific controls are being pushed on these guys. Representations and warranties from third parties. Again, this is very atypical. I saw this in the defense sector, so you're seeing it here where you have to, as a third party, be able to give a certification and represent warrant that you can meet the terms of Part 500. So essentially that they are effectively liable as well as you are. You have 72-hour breach notification. That's a big change from what most organizations have to do right now. It's anywhere between 30 and 60 days for most organizations. So again, not unlike GDPR, which uses that same standard, or defense contractors use the same standard. Also, there's a focus not just on protecting information per se, but on information systems and then on customers. So I think that's a sea change that we haven't seen previously, where it's been an emphasis on protecting information. It's been centric to that, but not really on information systems, again, with the exception of perhaps the federal government. And yes, I know there's more to this. If you've been involved in this regulation over the past 2 years, there's all kinds of controls. I'm not really going to spend a lot of time on most of the controls in place. You're already well versed with that, presumably, over the past 2 years. So let's go to the next slide and talk about non-public information. So essentially personal information. Again, an area that didn't really get a lot of press. I think a lot of the press went to specific controls like encryption and MFA and all that. That's great. But think about the different kinds of non-public information. You've really got two big buckets. You've got business-related information and things that if the information was lost, it would have an adverse impact on the business. That's important because really what they're talking about here is trade secrets, confidential information, internal practices, things that a threat actor, a state actor would want to have to steal. And then secondly is the other bucket of regular personal information, if you will, and that really has three different pieces. You have information that an individual provides about themselves or that the cover entity gets from them in connection with providing some kind of a product or a service. So that's item 2. We go to the next slide, though. Some other things that are pertinent. One is information that's related to healthcare, and this is basically copied and pasted from HIPAA High-Tech, this idea of providing healthcare information, provision, past, future, present, etc., provision, payment, what have you. So basically copied from HIPAA High-Tech. And then information that can be really used to trace someone's identity, said in a different way, information that can be used to create identity theft, identity fraud, what have you. So this is, I think, somewhat expansive on what GLBA does. So, for example, if we go to the next slide, look at the GLBA difference here. So under GLBA, information that individual gives you, you being the entity. So your name, address, income, social security number, information about the transaction, so account numbers, payment history, what have you, and then information you get from a court record or consumer report, so information that you get about the individual. So you can see how much more narrow this is under GLBA, which came out in 1999. So you can see the big difference here. And if we go to the next slide, I can show you that we have some differences here. So under Part 500, what we really have is an explicit acknowledgement that information that's especially critical to the business, like IP or confidential information. And that's important, and you'll see why in a moment, but the net of it is that it's not just personal information as we all understand it. It's really information that's critical for operations that if a bad guy stole it, they could use it to their advantage, either to hurt the organization or to help themselves, or both. Also, state actors would presumably want to have this as well if they wanted to create some kind of disruption. You have healthcare information, which is nothing new terribly about that, but it is called out as its own separate thing above and beyond what GLBA requests. And then information that can be used to trace someone's identity. So again, trying to protect personal information for its own sake and trying to prevent identity theft. So it's a big difference versus GLBA. Put aside any of the controls that are required, just the protection of personal information really represents a difference in how we're viewing it. And it's not terribly surprising given that GLBA was passed in 1999. The rules came out over the following 2 years. The idea of what's personal information has evolved over that time. And as a consequence, we can see why this is so much bigger. Let's go on to some trends here. So I want to talk about some key trends in data protection, which helped, I think, promulgate this regulation, but also I think we're going to be working to help make it potentially a national standard. So one is that we had a series of very significant thefts of intellectual property and personal information that just happened over, say, the past 5 years, for example, and then just breaches in general. So let's talk about the theft of IP first. To your right on the screen, you're seeing a lawsuit that was brought by T-Mobile against Huawei, which is a giant Chinese IT company. Think of them as kind of their China's version of Cisco. Brought the theft of trade secrets against Huawei in 2014. By 2017, there was a verdict for T-Mobile. Also, federal prosecutors in Seattle are now pursuing a criminal case against the company based upon this. And this is completely separate from the other things going on about arrest of Huawei officials for trade sanction violations. So completely separate. So a potential criminal investigation going on now against the company for theft of trade secrets. And if we go to the next slide, seeing here also just noteworthy breaches. And I'll give you an example in the hospitality industry, and I'm not picking on these guys, but you've probably stayed at some of these properties. So Marriott, Radisson, Hilton, Hyatt, Hotel Intercontinental, all these have experienced some kind of breaches. The Sabre reservation system, that's very common to use among these organizations, that's experienced a breach. So it's just noteworthy breaches are seen to be everywhere, and it's a problem that's just not going away. And one of the big issues here is this idea of Internet of Things, that you could have great security everywhere else, but have some single device become a weak link in the chain. So Internet of Things, said a different way, connecting things to the Internet you probably wouldn't necessarily expect. All the jokes about your refrigerator connecting to the Internet or connecting your thermostat or whatever, having them hacked now have come true. And if you really want to have a little bit of entertainment with this, is go do a search for hack internet connected fish tank, and you'll see the story of how a casino got hacked because they had an internet connected fish tank. I'm not sure why it was necessary to connect to the internet, but they did, and evidently did not throw up a firewall in between the two. Also, Bruce Neer's book, Click Here to Kill Everyone. If you have not read this book, it's excellent. It's all about Internet of Things, security or lack thereof. And so, again, a key trend really is just this multiplicity of breaches and hacks that keep going on, and the weaknesses in Internet of Things and other vulnerabilities, if you will, in the chain. Let's go to the next slide. Some key trends in data protection. So one key trend is this idea of an ethos of U.S. state industry-led data protection statutes and regulations. And what do I mean by that? Well, if we go to the next slide, we'll talk about the NAIC, because this is becoming something that's just huge. In 2017, October 2017, the National Association of Insurance Commissioners adopted the Insurance Data Model Security Law. And for all intents and purposes, it's based on Part 500. It doesn't track it perfectly, but just for the sake of this webinar, it's basically the same thing. Same month, the U.S. Treasury does a report on asset management insurance. They endorse the model law and essentially say this better go nationwide within 5 years, or Congress will step in with a law that preempts state law. Folks, whenever you see the word preempt, that should be a red flag, because essentially what preemption means is that the federal government's going to come in and essentially take over. And you think about laws in the past that have regulated cybersecurity, CAN spam, for example, which is really more of a cybersecurity and privacy law. It was something that was passed years ago to stop spam, allegedly, and it really didn't do a very good job of doing so. It stripped the states of their ability to go and go after spammers because it preempted state law. So was not a big success at all. And the idea that this is potentially going to preempt state law is something that is essentially waving a red flag in front of the states and saying, you know what, either you get your ducks in a row or we'll do it for you and you won't like it. That's really what the undertones of that is when they talk about preemption. So South Carolina adopted their version of this in May of last year, enforcement starting this month. And Ohio and Michigan adopted it over the Christmas holiday. So I suspect that we will see more this year. And I say that because I spoke with some experts at a security conference last year about this very model law. And they said that they expect about another 15 or so by the end of 2019. So I think it's safe to say that just with the impetus of U.S. Treasury saying go out and do this, you'll likely see NAIC spread throughout the nation over the next 2 to 3 years. And if it does that, that's going to be a national standard, at least for financial institutions, at least for insurance companies. But I think it's a great opportunity to create a line in the sand and say, okay, at a minimum, we're going to hold insurance companies accountable to this regulation. Let's go to the next slide. And so some other key trends here. In the last 13 or so months, at least 14 market-facing state-level data protection regulations have passed. When I say market-facing, meaning things that affect you and I, so things that aren't purely internal to a government agency. And you can see on the right all the different states that have gotten involved in this. Some cases, more than one law. In case California, you had 2 laws. You had the Internet of Things, and you also had CCPA. I believe this represents a sea change in how data protection is mandated. So the states have decided, you know what, federal government's not doing anything or can't do anything, we're going to do it ourselves. And so you're seeing all these state-level regulations. And what's interesting about them is that they apply to anyone that does business in the state. So you don't have to be headquartered in the state. This is a big misconception. Do business in a given state and you're subject to their laws and regulations. So CCPA, probably the best example right now, California Consumer Privacy Act. It's been called the new GDPR. I think that's fairly accurate. And I say that because it's so comprehensive. It covers anyone doing business in California, and it may cover you even if you only have one customer. It's still very unclear what the scope is, but it could be as few as having one customer or one data subject, for example. We're going to see the law fleshed out a little bit more during the course of the year, but the net of it is that that's coming online end of this year, but it looks back 12 months. So organizations have to start prepping for it now because it's looking at your data security practices and privacy practices now as opposed to January 1st, 2020. So a very interesting aspect to that. No federal data protection regulation on the horizon. I know that you're probably reading in the industry press that this year is going to be the year of a federal data privacy law. Right now, the federal government can't agree on anything. I would be shocked to see any kind of a federal data privacy law. I just would. And I know that runs counter to what you're reading in the press. I just don't see it. And I think we may have reached the point of no return, in fact, where I don't think we can have a federal data privacy law because the states are basically taking it on themselves to go and do it for the federal government. So whether you agree with that or disagree with that, the point is that state-level data protection is huge, and it's not going away. In fact, it's becoming more of a regulatory burden than anything else. Let's go to the next slide. Some other key trends I wanted to share with you. This idea of a requirement for a written information security program, or a WISP. At least 24 states have this requirement. Sometimes they won't call it a written information security program. They'll just call it an information security program, and presumably it's going to be written. I don't see how it couldn't be. But at least 24 states have this requirement. Massachusetts, you're probably familiar with 201 CMR 17. That's the original one, if you want to call it that came online about 10 years ago. recently updated to address breaches a little more comprehensively with a little more detail. Also, this idea to flow down information security requirements to third parties or conduct due diligence or both on them with respect to their ability to protect non-public information or confidential information. We know that Alabama, Colorado, and Nebraska have all enacted laws in the last 12 or so months to address such requirements. They're not the only ones, but I'm just pointing those out as fairly new ones. This flow down requirement, this idea of flow down to begin with, again, this is something borrowed from the defense industry. And you're going to see this happen a lot now, where it's not just a question of contractually requiring third parties to protect personal information, but having specific requirements flowed down to them with respect to, say, encryption, multi-factor authentication, breach notification, etc. Also, influence of the EU GDPR on FIs. If you offer goods or services as an FI to European data subjects, then yes, you're subject to it, but suppose you're not. Suppose that you are a service provider to one of those. Well, I worked on a project before I joined Sperion specifically about working on Midwest banks that were third-party service providers to these other institutions. They had to adhere to GDPR simply because of the nature of the data they were looking at. They were looking at EU data subject data. In many cases, they had to do OFAC checks against this to make sure that they were not dealing with parties they shouldn't be dealing with. So that OFAC implicates personal information, implicates GDPR. And so just as an example, even if you don't directly do business in the EU, GDPR still touches you as an FI. And so this is something, again, that's easy to miss, but it's absolutely relevant. And let's go to the next slide. So are there other candidates for a national standard? The answer is yes, but, and I'll give you two examples. One candidate is NIST Internet 171. So this is required by the federal government when sharing what's called controlled unclassified information, CUI, with contractors and with state governments and with their contractors. So this is not just centric to the defense industry. In theory, any controlled unclassified information from any agency, it could be from the Department of Energy, Education, what have you, that's shared with a contractor, has to use NIST Internet 171 as a standard. The problem with this is that it only addresses the confidentiality leg of the CIA triad, doesn't address availability or integrity, so you're still going to have other controls in place to address those as well. So that's one point. Second point is CIS CSE Top 20. So many of you are familiar with this. This was recommended by the California AG's office several years ago in this report called California Data Breach Report. And this was under the imprimatur of Kamala Harris, who was the AG of California. One of the interesting things about this, if you look at the second sentence here, it says that the failure to implement all the controls that apply to an organization's environment constitute a lack of reasonable security. I've emphasized that because that's the kind of thing that if you were in a court battle about what was considered reasonable under the standards, now you have the AG weighing in on this. Very big deal. If you haven't read this, I put the link there. Highly recommend to take a look at this after the webinar, because really if now the bar isn't raised for data protection here, at least for those doing business in California. Let's go to the next slide. Questions that were asked in advance, so I'm going to do my best to cover those now. And again, if you have other questions, you can feel free to send them in. So where an FI has contractual security controls expectations, how are with respect to third-party service providers, how are FIs responding when they say they're exempt? And I think the issue here is that even if a TPSP says they're exempt, they can say whatever they want. But the fact is that if you have a contract with them and you are flowing down all the requirements that you have on them, the onus is still going to be on them to say, to be able to adhere to those or not. And if they can't adhere to those, then presumably they can't do business with you. So their ability to say, well, I'm exempt, I don't have to follow these, I think really is going to likely fall on deaf ears. If that's something that comes up, that's really something that legal will get involved and say, well, you can say you're exempt, but you're still having to follow all of these things. Our next question was how to semi-automatically continuously check for compliance. And I think this really boils down to the InfoSec team setting up triggers of some type to be able to say, okay, we believe that this event or this incident or even just something that pops up on the radar of the Security Operations Center, we think that this merits closer scrutiny, and therefore, based on this standard, we think that this is matured into an event or an incident or what have you. I think that's one way of doing it. I think ultimately, it's not a legal question. It really is a technical question, and the InfoSec team should have a really good idea of how to continuously check to make sure that there aren't any security violations. As far as privacy violations, different discussion, then you're really having to police your third parties and making sure that they're not doing anything they shouldn't be doing with non-public information. That boils down to having a data inventory and being able to have a list of all the organizations that have access to the data and to whom it's being licensed or shared and what standards they're held to in terms of what they do with it and how they share it. And then you're going to have a mechanism to police those folks to make sure maybe it's spot audits or spot checks, but that's the kind of thing that you'll need, and that's apart from any kind of information security. What is the regulatory landscape in states other than New York and South Carolina? Are there new regulations on the horizon? I did an entire webcast on this. In fact, I think it's on our website. We'll do another one probably in a couple months. We're going to see the NAIC model go much more popular this year. Again, I said probably another 15 or so states. It may even be more, but we're going to see that. I think that's a big change. And then we'll probably see more states introducing cybersecurity, privacy, and regulations. I know here in Washington, we're considering them right now, in fact. So I think that this is going to be a big deal. And since many states have part-time legislatures, they do most of their work in the first 60 or 90 days, we're going to see a lot of bills going through those various legislatures with respect to privacy. And the final one was, is the regulations based on asset size? Yes. If you have more than $10 million in assets at the end of the year, you're subject to this. Even if you're quote unquote exempt, even exempt organizations still have a lot of requirements they have to fulfill, even with that exempt status. So you're not off by any measure, but by being exempt.
You touched on both of these, but I'm going to read them just if there's any additional points to expand upon. Could you please speak to the rule exemption provisions which many non-New York financial institutions qualify for?
The answer is I would need something a little more specific to that. I mean, that could be half a webcast by itself. So if they want to write back in and give something a little more specific, I'd be happy to address that, or I can just address it in an email.
Okay, great, thank you. The second one is, what is the chance for this regulation to be applied nationwide?
I think it's almost 100%. And I say that because the idea that states do not want to have preemption. That's really the big fight right now for a federal privacy law, if there was such a thing, is that states now have a lot of experience in protecting privacy and security. They're not going to want to give that over to the federal government. And just for the benefit of the non-lawyers, which I presumably is everyone on here, the idea of preemption is this whole idea of federalism, meaning the sharing of power between the federal and state governments. And state governments don't want preemption. They want to be able to run things the way they want to. And whether you agree or disagree, aside the point, the idea is that sometimes preemption is a good thing. You can make the argument that you don't want 50 states regulating aviation. The FAA should really have complete authority there. In some cases, it's a better idea to have local control or local standards, or at least have the federal government have a floor and allow you to create your own ceiling. So that's the idea, and I think that the NYCRR model at a very minimum is going to become a national standard for insurers. I suspect that other financial institutions, regulatory agencies across the nation are going to pick up on NYC Part 500 only because any FI of any size is likely licensed in New York City. And so they're already subject to it. So I think really it's almost a fait accompli in many ways that this is going to become a default national standard. That's what I think. I mean, stay tuned, but we'll do more webinars on this over the course of the year, but I think it's safe to say that we're looking at a national standard almost right now. Then let me wrap up here, and then I will take some more questions if we have time. So if you're a financial institution, insurance company, or something like it, or you're a TPSP to any of these, and you're already considering moving to a standard, let's presume that you're not necessarily subject to Part 500, I would consider implementing it anyway, because it's likely going to be a default standard. It's very aggressive in requiring the appointment of a CISO, in the appointment, reports to a board, which I think is the key into getting any kind of data security privacy project funded. And it's just good practice to have someone ultimately responsible. Note, you're still going to have a separate privacy program to account for use and sharing of non-personal information and regular personal data. So a good example here is CCPA. That regulates employee data. And so even if you're completely compliant with Part 500 or NAIC model insurance law, you still have to address personal data of your employees. especially if you have staff in California. That's CCPA. So it's just because you're compliant with Part 500 does not mean you're compliant with CCPA or other state level laws. And in fact, CCPA is really focused on privacy. It has very minimal requirements for security. In light of recent changes, review data protection requirements for all states in which you conduct business. You can't presume that just because you're compliant with one, you're compliant with all. Every state has its own unique set of requirements. All 50 have data breach notification standards. Probably all 50 have safe disposal standards. So it's not safe, for example, just to throw something away or just to delete it. Now you have to have a certificate of destruction or something else to show that you really had it destroyed. Also, regular standards like WISPs and so forth that we all take for granted, I think you're going to see that go nationwide as well over the next 3 years or so. Don't expect a federal privacy law anytime soon. I know that's contrary to what you've been hearing, but I think that's the case. Any other comments or questions before I wrap up, Abby?
Yes, we have one more question. It says, since you believe this will be nationwide, do you think it will be adopted as is by other states, or will there be nuances?
I'm almost certain there will be nuances. And I say that, for example, that the NYC model that was adopted by Michigan, for example, gives you 10 days to breach notify, if you will, as opposed to 72 hours. So no question there'll be nuances, which means that your legal department will be plenty busy keeping up with all of this. So there's no doubt about it. In fact, your legal department's probably plenty busy anyway, but they'll be even busier. Anything else, Abby?
That's all the questions that we have for now.
Okay. Then we have one final thing, and it's some additional reading, if you like. We have a white paper specifically on how we meet NYCRR Part 500 requirements. So please go to the website and have a look at it. And if you have further comments or questions or feedback, please let us know. Always want to know how we're doing here, and we will definitely. Yep, there's my email address right there. Please tell me what you think and what you'd like to see on a future webcast, and we'll catch up with you probably in the next 4 weeks or so.
Awesome. Thank you all again for joining us. Again, a copy of the PowerPoint presentation and a link to this webinar recording will be provided in the coming days. A huge thank you to Scott for a great presentation. We hope to see you all at future webinars. Thanks again and have a great day.